Where is the letter? This court, by order dated 17/12/2024, had directed to dispose of the suit, which is of the year 2009, as expeditiously as possible, but not later than 3 months. Now, a letter is addressed by the learned judge stating that they have received the said order on 1/2/2025. And the time granted by this court will be concluded by 17/3/2025. Hence, requested for extension of time, considering the same, considering the letter dated so and so. The time is extended by 3 more weeks, and as this is a suit of the year 2009, it shall be disposed of without seeking any further time. Yes.
List number 1 for pronouncement. Serial number 1, Muralidhar N.
I prefer the appellant one.
The order dated so and so is set aside and the matter is remanded back to the tribunal for fresh consideration. Accordingly, appeal is allowed. Without further reference, the party shall appear before the tribunal on 23/6/2025, and the tribunal shall decide the case as expeditiously as possible, but not later than 6 months.
Serial number 2, Rohan Kotari.
Allowed.
Obliged.
Part matter. Serial number 3, RB Sadashivappa.
So that I understood you yesterday also. That you submitted yesterday. Now what they have to say?
I will file my written statement to our statement.
Yes.
And request my lord to have it tomorrow, because today I got some throat infection.
Tomorrow.
Please.
Yes.
List number 1, serial number 1. The amount in deposit may
The amount in deposit shall be forthwith transferred to the, and shall be deposited in a FD.
It may be kept in fixed.
FD.
Please.
That you should add in that first order, MFA, the conditions.
Serial number 4, MFA first matter. Or on written submission. Serial number 4, Pramodar. No, nothing to fill out the form.
On 5/6/2025, there is no representation. The matter was directed to be listed for dismissal on 6/6/2025. On 6/6/2025, when the counsel appeared, this court has specifically asked the counsel for the petitioner what are the amounts paid by the father towards the maintenance of the children as well as the wife. and also directed the matter to be listed under the same captions. Today also there is no representation. Today there is no representation. Finally giving a final opportunity, list this matter tomorrow.
Serial number 5, Prasanna DP.
Petitioner in this matter, my lord. The petitioner seeking modification of the interim order, my lord.
Whether the mic is on or not, okay, mic there on the left side. Yes, what is the order? What is the modification?
Order was 30,000 per month. The dishonorable court directed me to pay 30,000
Where
per
is that? Date, order, the date of the order.
date of the order, my lord. 11/2/2025, my lord.
11?
11th February 2025, my lord.
So why an order that is passed on an IA
Please, ma'am.
to again to be modified by this court?
Since, my lord, it is ordered from the 2018, he has to pay. It reaches around 25 lakhs, my lord. He's
What were you doing that day?
no.
What were your submissions?
No, my lord. The order is passed in the month of December, my lord. But from the date of petition, it is ordered. From the date of petition, they have not pursued the IA from 2018 to 2024, my lord. In the month of December, the order is passed, my lord.
No, that's what I'm asking. This is not an ex parte order. Court has passed in your presence.
Please, my lord.
Nothing has been stated before the court, nothing has been recorded. Now, whatever the interim order that is passed by the earlier bench, everybody is coming up with an order, with an IA for modification of
but-
the order. No, in those cases, I will not entertain. Let this matter be listed before the very same judge. Please come. The coordinate bench of this court on 11/2/2025 has passed an order directing the petitioner to deposit 30,000 per month from the date of application till realization. Now, the IA is filed to recall the said order, to modify the said order. The earlier, on 11/2/2025, the court considering the submissions and had granted the order. And this court feels that it is not appropriate for this court to modify the said order. The registry is directed to place this IA before the judge who has passed this order after obtaining necessary orders. Yes.
Serial number 6, Kulkarni Malhar Balkrishna for petitioner.
Post for dismissal tomorrow. No representation.
Serial number 7,
Lordship, I appear for the petition. We have filed a memo for withdrawal, my lord, not expressed.
Memo. The memo is for seeking to withdraw the petition. So the memo is taken on record and dismissed. Yes. Next matter also same memo for withdrawal. Next 9.
serial number 9,
Switch on the mic. Yes.
I am told that there was a settlement between the parties. Petitioner section 13B has been filed before the family court. Probably this may not survive. Oh, really?
My lords, we have agreed to settle the matter, my lords. 10 days time, we'll file a memo here also. We have agreed to pay.
What is the memo here in a petition when the main MC itself is disposed of?
No, it has been filed
It
before
has
the
been
family
filed, my
court.
lords.
It has not been disposed of.
We have agreed to pay an alimony of 27 lakhs. We filed the application. Once it's disposed, we'll.
Will adjourn this
2 weeks, your lord.
for 2 weeks. It is submitted that they are going to file a compromise petition before the trial court, family court. list this matter after 2 weeks.
Much obliged.
Cell number 10. Memo for
In
withdrawal.
10.1 and 10 and 10.1, I have filed the memo for withdrawal. But in 10.2, my lord, they have not filed a memo. The other side has requested that, informed that his mother passed away yesterday only, and requested for
Council
adjournment.
is there online. Yes,
He is submitting, but.
Mother expired. I will file it on 26th or 27th, my lord.
no, as far as 10 and 10.1 are concerned.
I have no
we'll-
objection.
Three
That is
matters
set-
are one
that
and
is
the
settled.
same.
10.1 dismissed as withdrawn.
That is settled, my lord.
10.2 list this matter. When do you want?
25th or 26th, my lord.
25th, list this matter on 26th.
For withdrawal, my lord.
Come, you file the
Please, my lord.
withdrawn, dismissed as withdrawn, 10.2 will come up on the day he is asking.
Yes. Cell number 11.
I am for the respondent, my lord. I have received a copy of this just
You
today in the
received?
court. I request a week's time for me to file my papers and assess this court. 18th, my lord,
Opponent seeks a week's time, list the matter on 18th.
much obliged.
My lords,
Number 12.
the objections is there that the caveator must be served. I've already served.
Because it's already there.
It's
Office objections, the office of raise an objection that the acknowledgement is not filed, having served the copy to the caveator. Already, the council has entered appearance and submits that. He has been served with the copy. Yes, 12,
Cell number 12.
Please, ma'am.
Today, my lord.
today.
Mustaq Ahmad for the petitioner. Muhammad Ismailuddin.
For the respondent. This is the subsequent writ petition in respect of
No
the-
representation for dismissal tomorrow.
So lots, my name is
Tell him.
wrongly stated in the,
Huh?
my name is wrong, there's a typographical error in my name. Your Lord.
What is that?
Saduddin.
The spelling is wrong, Your Lord.
The name of the respondent shall be,
Shown. Bakpur.
it is submitted as a typographical error. It should be reflected as, write on a paper and give.
Great.
Yes.
Cell number 13.
In this case, my appearing for a petitioner, my lord. Petitioners have filed his.
What about the complaints of office objections?
There is only the annexure is not stitched properly. That is only the objection, my lord. Nothing, no objection.
Council submission on that.
There is only the, I will make a submission. The only the stitched is not proper. That's all. Nothing is there. No other. No other objection on my lord.
No.
No, properly not.
Office notice, the above writ petition papers were notified for so and so. Page number 152 to be stitched horizontally.
That's all.
Then what is the submission of the council for that?
I
That to
will-
be posted before the court.
No.
And
I-
why the registry is posting this matter? Is it a submission to be considered by the court? At least they should apply their mind.
No. One I have
That's
request.
not correct. Do it whatever is supposed to be
One
done.
submission, my
Once the
lord.
office objections.
One
are completed-
submission, my lord.
No.
That one stitches is not properly.
Then why should, you should do it? Why should you say that post it before the court for submission?
Alla, once-
To
one-
What you will submit on
My humble
that?
request, the day of tomorrow, there is a case is there in.
Your problem.
Alla,
You-
one
you
thing.
see- You do it, we'll see tomorrow. If the office objections or
Now today, no only dismiss, no only I
do
complain.
it tomorrow
Afternoon, 3 o'clock.
afternoon, tomorrow.
Cell number
The
14.
office, once the office objections are complied, list the matter tomorrow. If the office objections are complied.
Tomorrow, no?
Tomorrow, that's what I'm saying.
Please, my lord.
Cell number 14.
And tell the registrar judicial, these kind of matters shouldn't be placed. What is this? What is the submission? No, it is
that
not
is
that
only the annexure-
registry need not oblige for that. That they have said that it has to be, is it the court's duty to tell? No, that can't be. Nobody can compel them to do something. No, whether the court will see whether it has to be horizontally stitched or the other way. Tell the registrar.
That
Yes.
is only the small mistake in the desire.
All mistakes, it is not right on the part of the council to say, post it before the court for submission. What submission you will make before the court?
I wanted because due to the urgency itself, I moved the memo
That is
before.
a different issue, that you can move a memo before the court.
Please,
You
madam.
can't tell the registry that saying that when they raise an objection with regard to the stitching of the papers, for that you make a submission that it should be before the court. How is it
I
right?
requested,
Let
that
it
is.
come
the-
tomorrow, no.
And because day after tomorrow, there is a case is there in before.
Tomorrow it
the-
will come.
Please,
Cell
madam.
number
Do it.
Now shall I do it? Shall I take it with permission?
Yes.
I'm taking permission and file it too.
Yes, yes.
Cell number 14. Sadanandji Shastri.
Like to appear for the petitioner in this matter, my lord. Only three office objections are there, my lord.
No, what I'm not able to understand is, why don't you do it, and without doing it, what is this memo move?
Now, my lord, the urgency, it's a family
It's
court.
not that. For
No.
every matter, there can't be an urgency. What is happening? You are in all the matters, interim order is taken, and this office objections of 2025 will come in 2028 when orders forever.
I apologize, my lord. I deeply
Please
apologize.
do whatever it is to be
My
done,
lord,
it
can
will
it
come
be-
tomorrow. No.
Can it be passed over, my lord? Because
not today.
as regards the visitation of the child
Tomorrow
matters, my
we'll
lord.
do it, doesn't matter in one day. The land council submits that he'll comply with the office objection in the course of the day. Once office objections are complied with, list the matter. If the office objections complied, list the matter tomorrow.
Great.
Number 15. Sarvana S for petitioner. Hearing on interlocutor application Isha S Kumar.
Yes.
Please.
एक मिनट
Memo ಏನಾದ್ರು ಇದೆಯಾ ಇಲ್ಲ ಅಲ್ಲ?
Yes.
Ma'am, before we go further, I would
the-
just like to court to know that the maintenance is not being paid as per the order of this court.
Please wait, please wait.
And the petitioner has no rights for audience if they are not complying with the court order as at all.
Where is the interim order?
Yes, my lordship.
Interim order passed.
Lord said, considered this issue and posted the matter today. Lord said, considered this issue and posted the matter today for hearing.
Yes, what is the matter about?
Please,
Where is the interim order?
please, the impugned order, not should get it, not at page 17. What's the,
When was this application filed?
what application?
IA.
But I'm on the merits of the matter, Lord.
That's why I'm also on the merits. When is an application for maintenance is filed?
Very well. That is in 2014, Lord.
Sorry, I think the learned counsel has got the date wrong.
Petition is filed in
2014.
No, the
Yes.
petition is filed in 2011. 30th November 2011 was when the petition was filed. It's only numbered as 2014 is because it got transferred from the municipal court to the family court after the family court was
So it is
instituted.
2011.
It's 2011.
Please.
30th November 2011.
What was the interim maintenance that was granted during the pendency?
Initially, it was 20,000, which was reduced to 12,750. Initially, there was an order for 20,000. He took an appeal to the appellant court and reduced the amount to 12,750.
Was it, is he paying that?
No, he was not paying that. I had to file recovery petitions to collect my dues. And eventually the case got finally passed and final order was passed on 20th January 2022, granting me an amount covering the maintenance which he has not paid for so many years. Since he was a man of means,
I want only facts, nothing else.
ma'am, the final order was passed on 20th January 2022.
Yes.
In that, the honorable court has passed an order with regarding to the maintenance that is.
Where is that calculation memo she has given?
Yes.
Just given a calculation memo.
I submitted in filing, I filed it in the counter on the same day, on 4th of June.
It's MC.
Switch, look at it.
On the first page is the order of the, final order of the family court.
Memo of calculation. Lords, after considering this, Lords had not extended the interim order, but I had
Oh,
made
finally
make a
we get-
statement that I'll argue on
For
merits.
that, I just want to know a fact,
Very well.
these facts, then you can advance your
Very well,
arguments on
very
the
well,
merits
very
of it.
very well.
On the first page of the memo itself, on the lower half is the final order of the family court. If I may be permitted to read. The petition filed by the petitioner under section 125 CRPC is hereby allowed in part. The petitioner is entitled for maintenance from the respondent as of under 1/1/2023 to 1/1/2013, actually 12 to 31/12/2016 at 1,80,000 per month, 1/1/2017 to 31/12/2021 and 2,30,000 per month, and from 1/1/2022 at the rate of 2,80,000 per month. The respondent is given 4 installments of each 4 months each for payments of the areas of maintenance. The first installment shall be on the 1/8/2023. The second installment should be 1/12/2023, The third installment should be on 1/4/2024 and the last installment on 1/8/2024. While calculating the areas of maintenance, the interim maintenance recovered from the respondent as awarded in this case and in the divorce case shall be deducted. The petitioner is also awarded cost of litigation at 2,40,000 at the rate of 20,000 per year from the date of filing of the petition, excluding the litigation cost already, if any, ordered by the Honorable High Court or by this court, which shall be paid by 1/8/2023 along with the first installment of the areas of maintenance. Further, the petitioner is entitled for interest at the rate of 7.5% per annum on the areas of maintenance and cost of litigation if the same are not paid within the stipulated time. This was the final order of the family court.
Yes.
And the petitioner came before this honorable court and filed an RPFC and sought and stay. There was a condition put up by the division bench, and that order is there in the next paragraph, if I may be permitted to read. As per the trial court order, maintenance is in areas from 1/1/2012, interim stay of execution of the impugned order subject to the petitioner depositing 50% of the accrued maintenance awarded at the rate of 1,80,000 per month before the executing court within 1 month from the date of this order. This order, instead of complying with the order, they took the matter up with the Supreme Court and filed an SLP. The SLP was filed in January and it got dismissed in November 2000.
And what is this after noticing prompt payment of rupees 1 lakh?
Yes, because the interim order in the Supreme Court was to pay 1 lakh till the matter got heard. And that 1 lakh he was paying regularly. There was no default, there was no even an application put to reduce the amount. Once the Supreme Court judge noticed that the payments have been made clearly, the Supreme Court during the hearing said that we are not entertaining this application, please go and comply with the High Court order.
No. I'm not able to understand that. Is it an order to pay 1 lakh or what? What you have mentioned at paragraph number 4?
That was the interim order before the Supreme Court to pay 1 lakh till the Supreme Court hears
pendency of that SLP.
During the pendency of the SLP, which he paid regularly till it got dismissed.
How many months it was pending?
That from January till November.
So for 11 months he was paying 1 lakh.
1 lakh.
After that he stopped.
After that he stopped. And when we came back before this Honorable High Court, they have filed an application to recall the order of the High Court, which cannot be entertained because they've already taken benefit of the order. The order is binding on them.
Litigation expenses are paid?
Pardon me?
Litigation expenses?
No, nothing has been paid. Only 12,750 he's paying every month now. And that's the reason I have put in the calculation, even minusing as per the family court order, what was the...
When the petitioner left to US?
As per what I know, since 2022, he's been staying abroad. Unless his passport is brought before this honorable court, we'll know clearly when has he's traveled.
And the lookout circular is issued?
It was issued only recently because every time the police went to arrest him or for the fine levy warrant, he was not there in the country. The staff kept telling he's out in USA. It was in April that the LOC was issued. And he was arrested in May. After the Learned Counsel got a order from this honorable court that I should not precipitate the executing case. As per the calculation, 3 crores 56 lakhs 94,875 is due as of today, my lordship.
Let's make one submission. Let me make my arguments on merits. Now, she is just going on the issue of calculation. Let me make a submission on merits.
I'll hear you.
Because the difficulty is, Lord, it will prejudice the court. The kind, what is being done, in fact,
no, at least don't come to that conclusion that court will be prejudiced.
No, I'm not saying
because
court will prejudice, but that's the intention.
Case. No, why I am asking her is, it's her case. So with regard to every minute detail, whatever, that's why I said, I want to know only facts, nothing else. Which will be helpful for the court without wasting much time to straight away understand what you're saying.
Very well.
Yes, please make your submission.
Please. Lord, can I request notes, please turn to Lord page 17. I'll straight away take notes to the order.
17 of the order, yes.
Lords, please turn to Lord.
Are you referring to the internal page of the order? Or the
No,
running
Lords,
page?
the ink page numbers.
Hmm.
Lords, want me to refer the internal page number? I shall.
Whatever it is, 17.
Page 19.
Paragraph number?
Lord, can I just take notes to page 19? This para number 2, continuation of para number 2, bottom of page 19. Lord, the respondent, Lord, is a US citizen. And Lord, she was working in US in Citibank. And I think the salary was about Lord $6,000 per month.
Yes.
Lord, bottom of page 19, if not, please turn to. Lord, this is her statement. I'll just take notes of 3 sentences from the bottom. One or the other pretext he had received about 1 crore from her parents as hand loan. As he was in debt in financial crisis, she sold her jewelries and other assets to clear off his debts. But he was spending money to purchase gifts to his girlfriends. When she found that there was no chance
My lordship, I just
of
want to know
change
what
in his
paragraph he's reading and not what the
two.
paragraph of the order. Perfectly fine. Thank you so much. Sorry for the disturbance.
Yes.
She asked for divorce, and at that time, he started making false accusations that she was having an affair with her male friends. But then, please, then turn to Lord para 21 at page 34. So the reasons coming from para 24, page 24. But this is what the court says, Lord, is the basis. Lord, or shall I take notes of the reasons itself, Lord?
No, let's see. Like the manner in which you want to, please proceed. 34.
Lord, page 24, reasons comments. I'm sorry, can I take notes? Page 24 for a moment?
Yes.
Page 24, Lord, para 10. Just to point out, Lord, at para 10, the last 3 sentences. It is submitted that both the petitioner and respondent have contested more than 75 different cases before different courts, from the learned JMFC up to the Honorable Supreme Court. But then, not a para 11 onward, court not deals with the scope of 125. Not, I'll not trouble reading that.
I think you can
Not
come
page
to
34.
94, 19, para 19.
Very
or
well. I'll start from 19. On the other hand, respondent.
21, you can come to 21, paragraph 20.
Please. Para 21. At this juncture, I feel it appropriate to mention some of the most relevant admitted and undisputed facts between the parties hereunder. The petitioner is qualified physiotherapist, whereas the respondent is a mechanical engineer. Officially, they got married on 19/3/1998 after having love affair for considerable time, and also they had informal marriage at Brahma Temple. The respondent earlier belongs to middle class family, as his father was a carpenter by profession. Before marriage, he had started the business of manufacturing spare parts of watches, and subsequent to marriage, he purchased immovable property at Derlikatte, established his factory, residential house, guest house, and other buildings. He was the proprietor of Shagal Precision India, a unit of manufacturing spare parts of watches of 100% export quality. Before marriage, the petitioner possessed green card of America, and even her other family members were also holding the citizenship of the USA. On 12/10/2000, they were blessed with a son who subsequently named as Yash. She delivered her son at Maryland, USA, and therefore he is having citizenship of USA. Later on, between 2009 to 2006 to 2009, she served at Citibank and obtained her US citizenship. The respondent since beginning had the habit of possessing different types of vehicles and wristwatches, apart from his other luxury habits. But just pausing here for a moment, but the tenor of the admitted facts that the court says is basically not what the respondent had stated. And that the court says are admitted facts. And that is how the entire approach of the court has been. Even he visited USA on several occasions, and even he worked in USA in Armani cloth showroom. Apart from, he traveled different parts of the world, such as Switzerland.
You can come to the next paragraph.
Very
It's
well.
all not relevant.
Very
Paragraph, page number 36, in the said proceedings, she obtained protection order.
Please. Said proceedings, notes are referring to obtain protection order and also separate residential order. Thereafter, on 30/11/2011, she filed present application before the learned JMFC for maintenance, numbered as so and so. She also succeeded in getting an order from interim maintenance of 20,000 per month, which was reduced to 12,750 per month, as per the order of the sessions judge in so and so. Thereafter, the petitioner filed OS number 1 of 2012 in connection with 20 cents of land standing in her name, which later on came to be decreed in her favor. On the other hand, the respondent filed OS number so and so before this court for injunction restraining the petitioner hearing from entering his property, which later on came to be dismissed. He has also filed MC number 226 of 2012 seeking divorce on the ground of cruelty, which also came to be dismissed by this court. It appears that the respondent being agreed by the all said judgments passed in OS number so and so and MC number so and so has preferred appeals before the Honorable High Court, and same are pending for consideration. Even in MC number so and so, the divorce petition filed by the respondent, the petitioner herein obtained an order for interim maintenance of rupees 30,000 per month, which was subsequently reduced to 10,000 rupees per month as per the order of the Honorable High Court. After filing of this petition, the respondent, who was a proprietor of Shagil so and so, converted his proprietorship into a private limited company. Also, later on, it is contended that a Swiss company purchased Shagil so and so. Further, the son of the petitioner and the respondent is now a major. He is pursuing his medical education at Georgia. The petitioner, even though obtained protection and residential orders in MC criminal number so and so, and the respondent had agreed to hand over the outhouse existing in the said factory premises at Derlakate, but even for a single day, she has not occupied the same. The petitioner in her petition as well as in her examination in chief has specifically stated that though she was well qualified physiotherapist, but because of the future of her son and for the purpose of family welfare, she has given up her profession.
If you come to paragraph number 25, court says about his income is monthly 40
Please.
lakhs. Where from it is emanated?
It's her contention. Lord, that's what I'm saying, Lord. What has happened is whatever the respondent has contended, Lord, is virtually taken as gospel truth.
What are the documents that are marked before the court?
Lord, documents that are marked, Lord, multiple documents are produced. Lord, more than 100 odd documents are produced.
Let's understand from the appendix.
Very well. Lord, if we also turn to the very next paragraph, para 26. The court refers to the IT returns. Then, Lord, so please then turn to para 31 for a moment at page 43. Respondent, though had admitted that he was
98, the business of the respondent was running under loss.
Yes. No, please then turn to page 43, para 31.
Para?
Para 31, Lord.
Yes.
The respondent, though, had admitted that he was a proprietor of Shagil so and so, but he tried to make out a case. Lord, this is usually a contention raised by counsels, not what the court would say. He tried to make out a case that he was constrained to convert the said proprietorship into a private limited company, in which he started working as a CU, and later on the said company, the said company was purchased by a Swiss company, and thereafter he is now working as an employee of the said company and getting 52,000 rupees as salary per month. He tried to project a case that presently his monthly income is not more than 52,000 to 55,000 and is having loan liability, and therefore he is not in a position to provide maintenance as sought by the petitioner. Here, it is necessary to note that he converted his business into private limited company and sold it to Swiss company only after the dispute arose between himself and his wife. Lord, I'll just pause here for a moment. Lord, I have placed on record the letter, what she was a guarantor to the loan transaction. Now, Lord, she withdrew her guarantee. Then the entire thing, Lord, tumbled down because the guarantee was not there, property was involved. And Lord, therefore, ultimately the situation was such that, Lord, the company, Lord, had to be sold. Therefore, Lord, what remained in the company was basically only some of the machineries, etc. There was nothing else. And therefore, Lord, even now I'm only working as a CEO. I've produced documents also in this regard. But here the court extracts, Lord, my cross-examination, where, Lord, he says, I admit that it was converted after the dispute arose. Then, Lord, it goes on to refer to para 32. Here it is necessary to consider documents produced by the respondent. Respondent number is styled as a memorandum of understanding between the respondent and Shagil so and so in connection with the purchase of Audi Q3 so and so. As per the contents of the said document, the company was intending to purchase the car, but the bank had refused to sanction loan in the name of the company. And as the bank agreed to grant loan of 30 lakhs in the name of the respondent, therefore the said company entered into memorandum of understanding in which it authorized the respondent herein to raise a loan of 30 lakhs in his individual name, purchase the car, hand over the said car for the use of the company. And in turn, the company shall repay the loan, bank loan installments. This memorandum of understanding was entered into on so and so, subsequent to filing of this petition. Note that the said memorandum of understanding may be within the framework of rules and laws, but thing remains that as it is that the bank had agreed to pay him a loan of rupees 30 lakhs for the purchase of the said car, which shows his credit worthiness and goodwill in the banks. It is argued by the counsel for the petitioner that though the respondent has purchased the said car for his own use, but considering the litigation pending between both of them in order to hide the true facts, he has created a story of memorandum of understanding between himself and the company. The said submission cannot be brushed aside. What emerges is that the car was purchased in the name of the respondent. He availed a loan in his own name and repayment of the loan was made by the company in which he is a CEO. Earlier was a proprietor of the said business which subsequently converted to the company. From considering all these facts and circumstances, an inference, kindly note this, not an inference, has to be drawn that in order to suppress true fact, the respondent has created the said story. But in fact, he himself purchased the vehicle for his own use. But inferences, I'll take note subsequent portions of the order. The court says not adverse inference is drawn because I don't produce documents. In fact, prior to it, when application is filed not by the respondent seeking for summoning of several of these documents, and the court rejected it. The very court rejected it. Now, my lord, after that rejection was also challenged. Even in MC case, my lord, an application was filed. Now, my lord,
Come to paragraph 33.
please, my lord.
Paragraph 33.
33. Along with R1, he has produced notarized copy of certificate registration of several vehicles. In all the said document, it is shown that the vehicles are standing in the name of Shakil so and so. But the said vehicles were earlier standing in the name of in his individual name. But what this shows that subsequent to filing of the petition, he has transferred those vehicles name of the company.
What do you say on this?
Please note this. Not the entire thing was with the company. But it is not plot. In fact, I have produced the RCs also. Not so kindly see not exhibit R1. The documents are produced.
Yes. No, when is this? In the next paragraph, at
Please.
34.
There has to be a
says-
basis to come to this conclusion.
No, shows that one Jyotika Kamath, Sharashchandra Shastri, and V.K. Narayan as directors of the said company later.
Yes, ma'am.
Who were working with you or shown as
No,
directors?
they were earlier
when you
working
were
in the
CEO
company.
of the company.
Lord, what has happened is the company, Lord, was given as a going concern. It is taken over by a Swiss company. Normally, it has to operate in India. They're not for that purpose. They have retained some people. They've been made as directors. But insofar as I am concerned, I am made as CEO of the company. I am getting a fixed salary.
And when you have sold the company, what is the revenue that you have received?
Not that details, Lord, are not
That
available.
is the crucial one. No, you sell the company, which is purchased by a Swiss company. You must have had your share.
But there was.
Why would you sell the company?
There was a huge loan also on the company. In fact, not one document.
No, after the loan, what is the amount? That is an important aspect. And somebody in your company becomes the directors.
No, that is
you
because
become a
not.
CEO.
Not I agree what Lord's not running in Lord's mind, but the fact remains that the company was sold as a going concern. The company was not doing well.
Was those documents placed before the court, which are very much necessary to consider your financial status?
Not the.
You cannot say like with 51,000 I am living. If you are living with 51,000, you would not be in a position to pay the expenses of your son's education.
No, for which.
Studying MBBS in US.
No, not for which I have taken loan. But that document also is placed on record.
Now, when you can place a document of loan, why not the document which is pertaining to the sale transaction of your company?
I'll just verify why is not placed on record. Lord, I'll just seek instructions on that. Lord, can I just request you please turn to Lord the documents which are produced as Exhibit R1. But these RCs, Lord. My lords have it, Lord. But these RCs, Lord, this registration date and the name of the owner is shown. Lords, these RCs would reflect that these cars not reflect the name of the company, but not my name. The registration, Lord, of the vehicle.
Because we don't have to look at the document. That's what the court also said. Now it shows the name of the company.
Shows the name of the company.
Earlier it was in the name of the other company. Now it is in the name of, first in your name, then in the name of the company.
Lord, the only issue is, Lord, the court goes on to say that I have not brought document before the court and says that I have adverse inferences to be drawn against me. Lord, I'll straight away point out also the paragraph in that regard. The question would be, my lord, when can adverse inference be drawn against me?
What is the amount? $13,500 or equal to
13,000 US dollars, not
$500 per annum.
It's about 11 lakhs, my lord, at the rate of 80 rupees.
So 11 lakhs per annum. So is it, how many years is a course there? 5 years?
But I think it's about 5 years.
6 years, my lord.
6 plus
6 years.
internship.
Yes.
Plus internship.
That's only the tuition fees.
Please, my lord.
That's only the tuition fees. College
Yes,
fees.
yes.
So he requires other, so.
But he is getting a monthly, my lord, my son is getting a monthly income of about 50,000, not from Lord Shagil. Because the property, my lord, is in the name of my son. The rent is going, my lord, to my son. And that plus, my lord, I have taken loans.
All these things shows that whatever is the way the court had dealt with it, only to avoid paying maintenance to the wife. Your client is making all his best efforts in converting the company and seeing that.
No, my lord, the fact would remain that, my lord, for the purpose of not arriving at such a finding, Lord, it cannot be on the basis of not a perception or on the basis of assumption that, Lord, I am hiding something. Lord, I have, in fact, if Lord should seem, Lord, she has produced lot of documents in respect of certain companies, Lord, which have in fact not even taken off. Lord, in fact, those companies, Lord, have been closed as Lord inactive. I kindly permit to just show, Lord, the documents which I have produced along with my application for production of additional documents.
When did you sell the company?
Company, Lord, was sold in 2013. Lord, it was converted from a proprietary concern into a private company.
You start the company.
But the company, Lord, was initially started, Lord, in 2003 or so. It's a proprietary concern. It was at that juncture.
So where are you must, because you're running such a big company, you have your income tax returns from 2013 till that date were filed before the court.
Lord, 2003, Lord, 2003, Lord, the company was not doing well, even according to the respondent.
Oh, you must be having the tax and other.
2003, Lord, I'm not too sure. But
no, if you feel that
we have produced, Lord, if Lord should turn to the affidavit that is filed, Lord, we have produced.
Come to the appendix. What are the documents that are filed by you?
Very well.
Let us just see. If your client has no intention to suppress any of the facts, when she is making that kind of allegations against you, will these documents be sufficient to make out a case from your point?
Lord.
When she is making several allegations against you and as many as 155 documents she has produced before the court to show that you are not financially sufficient or having enough means to pay maintenance to her, will these documents will do 7 documents?
Lord,
when you have started business in 2003 and when you're running successfully for some time and again after some time you said some problem with the business, but what about your income tax returns?
But IT returns for 14-15, Lord, is also on
14-15 is not, it is like right from
but some IT
2003
returns are not available.
Company.
But some IT returns are not available. Lord, whatever is there, Lord, we have placed it on record. But that is my instruction.
You're a businessman, not that
True, Lord, but
that you will not keep your income tax returns, and in the income tax returns which are not available with you, you know how to get it.
Lord, income tax, Lord, department will only keep it for 5 years.
Your
Lord.
case is not really not, you couldn't make out anything.
So the fact remains that, Lord, if not permit, I'll just.
The court has no other option but to assume and presume things.
Lord, kindly see.
In these facts and circumstances.
No, Lord, it will not be so. The reason is this, Lord. If Lord, please see the quantum of or the maintenance that is also awarded. But it is awarded at the rate of Lord.
You only get 55,000. Your son gets 50,000 from the property. Your son, for your son, you pay about 65,000 towards 65 lakhs per annum.
Not per annum, Lord.
It's per annum. That's what, look at it. It's 11,000. Whatever I asked you, it is per year. That is there in the order.
Yes, tuition fees of not $13,500.
That
is for 1 year, Lord.
That's what I said.
Yes.
Every year you pay 11 lakhs.
Please.
So for 5 years, how much it would be?
But I have produced documents show the loans that I have taken. Not kindly permit me to just point out those documents as
How
well.
will you pay the loan?
But I am paying out of my salary itself, and not whatever income is that is generated not from the being the CEO of the company. That income itself, now I am repaying the loan.
For that, we will require all your documents.
But
All your documents are required. Your bank statements are required. Where
I
are
have
your
placed it
bank
on record. Kindly permit me to show, Lord.
From
Kindly,
when to when?
but I'll just point out. I have placed those documents also on record. Please turn to my application for production of additional documents.
No, that is from which year to which year?
But can I request now, please turn to my account statements, not.
From which year to which year, I'm asking?
But this is. Really there. I'm sorry. Memo documents. Huh? I'm sorry, Lord. Can I take request notes turn to the memo of documents? I'll take notes with the IA later. But I produced not.
Dated?
This is dated 3rd February 2025.
3rd February.
Please.
Yes.
But this is not for the period 2024, 1st April, first bank account of Canara Bank at page 44.
No, we are
Then
dealing-
Lord, I have produced at page 60 in respect of Indian Bank, that is not from 2011. That also not, I have produced not all documents with regard to banks.
Your opening balance itself is 37,37030.
Lord, sir, can I request which page Lord, sir, referring to?
I'm looking at 69. 69
69.
in the year 2018.
Please. But it is carry forward. Not there is a loan that is that I've taken also. Statement of account. This relates to not Indian Bank. It's carry. Not it is not 37 lakhs. Not. It is 37,000. Not. 0.7. 37,030. It's not lakhs.
It's not lakhs.
No,
It
no.
says CR.
Credit note. CR is credit there. It is not. You can also turn to page 68. Bottom. But it is 25,609.35 CR. That is CR, not credit. But this document, not which is at page 60.
Now, why, as on the day this order is passed,
Please.
the judgment of Rajneesh and Neha was already there.
I'm sorry, Lord. Yes, not we have placed. We have also filed that affidavit. That is also there.
It's a liability
Yes,
certified.
yes, it is fine.
All the bank accounts, because that has to go back to this 2014, because that's the day when she has 2011. That's
Yes.
the day she has filed the application.
True.
That is
But I have
fine.
that documents also produced. But if
2011
not
also.
turn to page, there's an order on 3/2/2023 of the family court, where not an order was made and not affidavit also is filed. In fact, it is also on record.
Have you filed any objections to this or your?
Assets and liabilities, because it was the High Court order, we were directed to file it, but he has not filed the whole thing. Even in the cross-examination, he's admitted that I have not complied with the High Court order. I have not filed the whole
Which High Court order?
assets and
As
liabilities.
per the format.
As for the format, nor the documentation has he filed. Even the IA that the
Ideal,
Learned
good.
Counsel mentioned, which was allowed in 5th December 2012, directing him to produce his bank statement, passport copy, and other relevant documents for the maintenance case, he's wantingly avoided, which he has admitted in his cross-examination.
What are the documents that he has not filed?
A2 of, it is
Not
being
before my
marked
lords go further. Can I also show?
marked in the file. If I may just be given a minute to pull out the document.
Lord, may I complete not my submission? Thereafter, my lord.
Even if you complete also with what is available, court will not be able to come to any conclusion.
My lordship.
But then, Lord, I would only, not, the point would be this. To court, the family court says, Lord, she is entitled for, Lord, traveling abroad. Kindly see, Lord, for what basis this amount has been arrived at. Lord, there has to be some justification to say, Lord, this is the figure that is arrived at.
It's like this. No, she has to be fair enough to tell the court that what is her requirement. And you should also be fair enough in submitting what is your income and what is your capacity. Now, you say that whatever the figures that she has stated are all exorbitant, and at the same time, looking at a bare reading of your occupation, your business, and the way you're running your life, this statement of saying that I'm earning only 55,000, I don't have any other amounts, doesn't appear to be believable on the face of it.
But the requirement, Lord, of going abroad is on work basis. Not everything is paid by the company because it's for company business. But company is not doing well. I have also placed on record to show the income, not the IT returns of the company as well. But it is not the case
from
where
2011 till 2023, personal and your company accounts, or in which banks you have, was it disclosed?
Lord, I have placed it on record before my lords along with the application for production of additional documents. I have placed various bank accounts, including what my lord
So
suggests
company
now.
bank account should also be there before.
Company bank account.
Not your, when you are running your business, and when it is running into crores of rupees.
Company
and that
not-
time, once it is run in your name, that is also.
It is not
that
run in my name.
It's a proprietorship.
Initially, yes, Lord. If my lords,
Bank account is also an important
not
thing.
the IT
And
returns.
please
Lord,
place before this court your bank account pertaining to the company before it is, before you sold it or taken over by a Swiss company, your bank account, and also.
no, my lord. Lords of passing an order, my lord.
No, that's what I'm going to pass the order.
No, my lord. My lords, kindly hear me for a minute. My lord, I have placed on record the account details that my lord is available with me along with my application. Now, my lords, also permit me to show, my lord, the documents with relate to the company as well. But I have placed on record the details of the loans that I have taken from the bank, from the company as well, the IT returns of the company, to point out not what is the.
Instead of filing those bunch of documents, why don't you summarize the whole thing? Because it's not possible for the court to go through each and every
Very well.
document.
Very
And
well.
what I want is this application is filed in the year 2014. Even as per Rashish versus Neha also, what is the service as on that day? What was your income?
Lord, even that Lord is pointed
For
out.
example, she filed it in, as she says, she filed it in 2011. When it is transferred, it is renumbered in 2014.
Yes.
And by the time the order is passed into the 2023. And you have not been paying anything to her in between.
No, I have been, but I have paid about 57 lakhs in all to her. Lord, I have kindly permit me to just pass.
Submission, my lordship.
Let me just pass on, Lord, the memo which Lord has these details. Lord, what has happened is, Lord, it is not that Lord she is not capable of working. She is capable of working, and Lord, she is a qualified Lord physiotherapist. She was working Lord in the bank, Citibank in US. She's a qualified banker as well then. But she has sufficient amount of money. Now what she says in her cross-examination, because not she has FDs in US, she does not give those details. But she is residing in Mumbai. Now kindly look at this scenario. But she says, I have not been able to survive. I am not suffering from XYZ is what she says. Now, Lord, if repeatedly she travels from Lord Mumbai to Bangalore or to Mumbai to Mangalore. But there are 75 cases that are filed. But I also pass on not how many cases that we have made a status of the cases that are now pending. But there are more than 30 odd cases which are now pending also. But for all these, she comes and travels. But I ask myself, if Lord, she does not have any source of funds. She says, I'm giving only 12,500 per month. Therefore, she has no other source of funds, etc. But how would she be able to survive and travel all this? Because she says that she needs much more amount to maintain herself. But therefore, there's something else also. It is not as though, my lord, that she is come to court with clean hands and that she has no source of income, etc.
The problem is both, if that's the case, then both of you are not coming to the court with clean hands.
According to me, Lord, whatever is available with me, Lord, it is placed on record. Lord, kindly permit me just show, my lord, this memo. Can I
I'm
request?
telling you with your submissions, with what is there on record, Nothing can be done. No order can be passed.
My lordship, if my lordship kindly just sees the counter that I filed for the recall petition, it shows the ID returns filed by him in 2011-12, which clearly shows his financial standing. They tried to tell the court that we were going.
How much was it?
It's right there, my lordship. I filed a counter on 4th of June 2025.
4th June.
Yes, a counter to the recall application filed by them. But along with that, I have submitted certain documents which were marked as exhibits in the case.
Ask for the day. We can do it. One petitioner's documents, one respondent documents. It would be easy.
Document or memo. Which page you're referring to?
The first document. Page number 6. Counter.
Memo of calculation.
No, there's a counter also filed.
Along with that memo of calculation.
A memo of calculation was filed in the court office. A counter was filed at the filing counter. That particular set.
This one, na?
Yes.
ಏನಂತಾರೆ ಇದನ್ನ ಕಳಿಸಿದ್ರಾ?
First document.
2, 3.
ಏನಂತಿದೆ?
3, 6.
Yes, page 6.
ಹಂಗೆ ಹೇಳ್ತಾರೆ, ನಾವು ಏನಂತ ಹೇಳ್ಬೇಕಲ್ಲ.
Yes.
My lordship, this is exhibit P115 that I've submitted before the trial court. And it is the income tax acknowledgement for the year 2012-13 filed by Shailesh Kumar. And on the 7th page, number 7, that's the following page. It is pertaining to his one unit. Now, my husband is a multimillionaire. He has a proprietorship company, plus he's directors in several different companies. He's also owning property which he's renting out and earning rental income. So he has a good amount of money. Just to avoid giving me money, he's made this
What
whole
is it
story.
you want to point out from
Right.
that?
So my lordship, if you see in the year 2012, his income at the end, net current access, 3,64,22,763. The following year also, 3,680,5,167. Both the figures have been there. In the next page is also his loss and profit. If you see, he has been making good amount of money. Having said that, even that was for unit 1. On page 9 is for unit 2. That is, the unit 1 was for
the same year.
Yes, for the same year, which is filed together as a proprietor of the company. So whatever he is earning is, even though if it's earning on the company's name, it is coming to his account. He's the sole proprietor, the sole owner of the company. He gets everything.
Till which year he was it was a proprietary?
Till 2013. He started the company in 94, but he was going under loss. Once he got married to me, my parents had pumped money into his company. Company has earned, he has raised high up. Now he's earning more than 400 machines. When he started, he only had 24 machines, my lordship. Now more than 400 machines. Plus he started with a CNC unit, which is the unit 2, which started in the year 2003. That went into some kind of problem because he forged the partner signatures and there was a case, criminal case filed against him. He ran out of the country. He was brought before the court, arrested, and things. His passport was confiscated. At that point of time, he forced me to take up a job in the US because I was a green card holder. I'd gone to see my dad who was having a mitral valve replacement in the US. He made me take up a job and all my earnings have been withdrawn by him by the ATM, which statements have been produced before the court.
No, the difficulty is you have to focus on what is required.
Agree, my lordship. No, the reason they are saying that
with regard to this case, because even if he does whatever you are saying, that the court can't help it.
Agree.
Court can only grant you maintenance basing on if you can show what is his income.
Right.
Nothing
This
else.
was his income. At the same time, my lordship, I want to take my lordship to page number 15.
Page number
15.
Yes.
It is the settlement deed done by him, transferring the properties which were mortgaged to the bank to the minor. Now, this transfer was done during the pendency of the litigation because there was a maintenance application filed before the trial court. And if you, my lordship, can go through the conditions in this, and I may be permitted to read the conditions specifically. the settler, that is he settling it to my son, he was a minor then, he was hardly 13 years old. The settler hereby settles all his rights, title and interest in the scheduled property in favor of the settlee. The settler hereby reserves the right of life interest over the scheduled property to himself. Since the settler is a minor, the settler hereby reserves all the right to manage and develop the scheduled property on his own cost. That this settlement deed is revocable without assigning any reasons. Clearly saying at any point of time, he can cancel the settlement deed if the transfer is also done. The settler hereby reserves all the rights to revoke the settlement deed at any time. Take on the strength of the settlement deed, the settler may take all the steps for transfer or mutation proceedings and the other connected revenue records to the name of the settlee. Then the 6th part clearly says the settler is executing the settlement deed with the sole intention of preventing the flow of devolution of rights concerning the scheduled property over to the other heirs. Now there is no other heirs, his parents have passed away. His sister is married and settled down with her husband. Just to avoid giving me maintenance, he is trying to show now the property is gone to the son. I am owning nothing. During the whole cross, the facts have come before the court that this transaction was done to avoid maintenance. And he has even collected a GPA from the son, which clearly showing, which I have submitted with the assets and liabilities, showing him that he's got the rights to collect the revenue generated from those properties to himself. Now, this is the hoodwink that he's trying to put over the court so that he shows that he's a pauper. When he's a man of means having so much money. My only prayer before the honorable court is to dismiss the petition with costs because they've been harassing me and not paying maintenance, not complying with any order of the court.
I'm not disposing it off. The criminal misdemeanors. I require an affidavit from your client. Let her also file an affidavit with all the details and particularly when you have sold this company to a Swiss company, what is the said transaction and what is your what you have gained from that.
We have crossed him on that matter. We have asked him. He said, I cannot disclose it to the court. I can take my lordship to the paragraph and clearly show.
The agreed with orders passed in criminal miscellaneous number 50 of 2014, dated 30th May 2023. The husband is before this court by order impugned. The court had.
Before my lords proceeds, not to pass the order, not can I just proceed, my lords, with few things, Lord. But one, Lord, I have produced what documents I have. I place it on record. Now, my Lord, if my lords permit me, I'll just take lords to the order further, my Lord. The reasoning that is given, Lord, I'll just kindly permit.
No, 1 minute. I've seen the order. Whatever you say, what you can point out that court court without any document, court has assumed or presumed the things. As such, it is not right. But what about you? You are also
Lord,
supposed to be.
I'll answer that, Lord. In fact, please see, Lord, what happened was an application is filed before the family court earlier as well to summon documents. So kindly permit me to show those documents. What the court has asked, and the court said it is not required. But please permit me to just show that, Lord, because what happens is, but it should not be a situation where the court said these documents are not required. There are several documents relating to the MOU, etc. that is referred to. Kindly permit me to just show that. Then if Lord still feel that I have to be directed to produce certain.
You can file an affidavit before the court that this is what it is. Whatever you are saying, file an affidavit in that regard.
So Lords are only saying that I have to file an affidavit.
Affidavit saying that giving the details, whatever the court now going to pass the order. Because both of you cannot, and she will also file, saying that what are her properties and what are her the thing. And if you say that she is having the means and she's and still she is pursuing this litigation, always court will initiate if the relevant material is placed. We can initiate perjury proceedings against the person who is.
My difficulty is, Lord, I'm not in a position to get her material. One, Lord, she is in Mumbai. Two, the money, Lord, which she has deposited, Lord, which is in US. In fact, in the cross-examination, her statement is, I have not updated my KYC in US. Therefore, I'm not in a position to tell what is the amount that is there now. But that is a statement in cross-examination.
You have the money in deposit in the
I don't have any fixed deposit because whatever I had to withdraw it and send $50,000 to him when he wanted to purchase a property in New Zealand. And for that, I have already produced the email where he's asked me to send the money. The money going to his hand is also being produced before the court, as well as he's taken money from my family, my cousins, my aunt, my sister. All those documents are produced as evidence before the court. They are saying that a document, that what FDs they are showing is a 401k, which is as per US standard, it is amount like we have PF in India, where an X amount is removed from the salary of the person and it is kept for retirement. You cannot touch it till you're 65 years old. So I cannot touch that amount. Even if I'm in dire need of that money, I cannot touch. So the question goes to them that when they know that 12,000 is not sufficient for a person to survive, how do they expect me to come? And this is the reason they are not paying the money, so that I don't come to court, I don't fight my case, I don't get any justice from the court.
Lord, I have been injured, Lord. She has attacked me. I have produced a wound certificate also to show, but I was attacked by her. Lord, that document also is placed on record. And now, Lord, the fact remains that, Lord, all these multiple cases that she has filed against me, Lord, all these cases, one after the other cases are filed saying alleging forgery. Then there's an allegation made that, Lord, I have forged a signature insofar as transfer of documents. Now, Lord, if my Lords would see, Lord,
kind of, matrimonial disputes. If the parties are feeling that courts have no other work but to deal with their egos and come up with these kind of petitions. Whenever these petitions appears to be for the sake of the egos and for not for any relief, if the court starts imposing exemplary costs worth their property, then they'll understand that they can't, like this, they can't come up with frivolous cases.
But I'll just
now this will not go anywhere. I'm telling you. You argue, she argues. It's not going to go anywhere because nothing. You have not placed any document before the court, and you are having such a flourishing business from 2011.
But I had, Lord, I'm not disputing.
But where did the money go?
Lord, I have, Lord, there was bank loan. In fact, Lord,
don't you feel that? Lord, if at all, if you're being fair to the court, and just so she's shown that settlement deed, I think I have never seen a settlement deed of that nature. It all shows to avoid payment maintenance to the wife. You have been trying all your means. And we can't let it go like that. And if you say that wife is also having means and doing, then it is nothing like it's a wife and husband, doesn't matter.
It has become like this, Lord. I am required to pay maintenance, Lord, and she completely goes on filing one after the case against me. But kindly see the scenario. We should not be pushed to a stage where like in Atul case, what he did. It should not come to that level. But please see 75 cases that are filed against one another. But it is not a case where wholeheartedly somebody.
You don't have to compare it with Atul's case, and you and both the wife and husband are enjoying this litigation, filing 75 cases.
My lordship,
but I am not enjoying it.
My lordship, the 75 cases are appeals filed by him for every order that has come in my favor. Any order comes in my favor. An interim order also which comes in my favor, he's taken it for an appeal. My lordship has just seen Exhibit P 115. You saw his standing at the time 2011-12. 20,000 was ordered by the interim court. He reduced it to 12,000, saying he doesn't have money.
Not, can I
just to harass me. My lordship has clearly figured out the fact that how they are harassing me. And bringing Atul into the picture is just trying to put pressure on the court to get it on their favor.
The court had granted.
Karma. Lord, I was requesting the court to see the memo dated 3rd February. Can I just request, Lord, just have a look at it, Lord?
Yes.
3rd February 2025 memo.
For what purpose?
For the purpose that, Lord, what documents, Lord, she had sought for summoning in this very case.
What are the documents?
Lord, the document that was sought from, Lord, was with regard to the director of the company to be summoned, then, Lord, to prove, Lord, the assets, Lord, of the respondent, and then, Lord, the documents relating to details of the bills of the company. That is not the company that is from its inception till date, but income tax returns of not Shagil, then name of the present CEO, appointment of the petitioner here, then, Lord, liabilities of the CEO, salary package, and memorandum of articles and association of Lord Shagil Precision, lease agreement between Shagil and Yash, and lease agreement again document, then tax paid receipts, details of personal loan taken by the petitioner, and bank statements of the petitioner, etc. All these were sought to be summoned. But the family court has rejected that
Will
application.
not ask any of it. Will not ask you to file any of it.
But bank statements I've already filed voluntarily because I want to point out
You
probably
always want to
by
file the
mistake
bank accounts of your personal bank account where you know that there will not be any money.
the account which is maintained. There are two accounts that are produced,
No,
two or three
you are
accounts.
maintaining what she has filed now along with the memo of your income tax returns and other things.
Yes, I'll point out.
Here you don't file that company's, at least one thing. Now you say you're working as a CEO from a particular date. Before that you were working?
Yes, but I
You
was.
were having a company? No,
Yes.
the Swiss company has taken over. What was the transaction between you and the Swiss company? We'll cut the issue. Why were you not placing it before the court? Very simple. Then from that day we'll say that you're a CEO and earning only 55,000. Right. The court. Where is that memo you are referring to? With regard to the.
With regarding to my lordship?
Yes. No, you have just now you have shown one memo wherein you have
the memo of calculation, my lordship.
No, this is
Not
it's
calculation
in the
before.
count
There's a
of,
counter for recall of application.
What is that?
it is for the counter
Counter.
to the recalling application.
Lordship, I had mentioned about the IA2, which was allowed by the Honorable Court, and you had asked for the list of documents that I had asked for in that IA. If I have got the document list, can I read it out to you, my lordship?
And it starts at page
That is dated?
6. It
Documents
is
start at
dated
page
4/6/25.
4/6/25.
4/6?
25.
Yes, got.
Proprietor.
The court had granted maintenance from 1/1/2020 to 31/12/2006 at 1,80,000 per month. From 1/1/2017 to 31/12/2021 at 2,30,000 per month, and from 1/1/2022 at 2,80,000 per month. And also court has fixed the installment and the time frame. Further, the court had awarded cost of litigation expenses at ₹2,40,000 at the rate of ₹20,000 per year from the date of filing of the petition. And also interest at 7.5% per annum that is challenged before this court. And this court had initially granted an interim order on the condition that the petitioner should deposit 50% of the accrued maintenance awarded at the rate of ₹1,80,000 per month before the executing court within 1 month from the date of the order. That order of the division, that order was questioned before the Honorable Apex Court. And the Honorable Apex Court had dismissed the SLP. In the meantime, court had directed the petitioner, the husband, to pay an amount of ₹1 lakh and the matter is pending from January to December, at that point of time, it is submitted that the husband had continuously paid 1 lakh rupees per month. Today, when on the last occasion when the matter came up, the matter is posted today for final disposal. When counsel appearing for the petitioner submits that on assumptions and presumptions, the court had come to the conclusion with regard to the income of the husband without any basis, when it is a specific case of the husband that is earning only 55,000 per month.
Now it's about, now Lord, it is reduced to about 40 odd thousand.
For 55,000 per month, and now it is reduced to
Reduced to about 40,000. It was 52.
it is likely to go further down, and it's difficult for the husband to pay the maintenance as granted by the court. The party in person, respondent wife, submits that the husband was having a good business. Once it was a proprietary firm, and she has placed before the court the income tax returns for the year 2012-13, wherein 3 crores and odd and 1 crore and odd were shown as income for the two units he was having. It is a case of the land counsel for the petitioner husband that thereafter, as he was running into the losses, he has sold this company to a Swiss company. And after that, the very same company is working as a CEO. This court had perused the order and the exhibits that are filed before the court. It shows that the wife had filed on her, both of them have examined as PW1 and RFD1 respectively, and on behalf of the wife, exhibit P12, P155 were marked, and on behalf of the respondent, exhibit R1 to R7A are marked. It is the submission that they have a son who is working in
No, he's not working, Lord.
who is studying MBBS, and the husband is taking care of the expenses. It is stated that 11,600
But
the
husband,
tuition fees.
My lordship,
Lord,
husband is not taking.
the husband is taking care in the sense, not the son has income from the rents that he receives from the property.
11,600 is the tuition fees. 11,600.
11 lakhs. It's about $13,500, Lord.
What is that? 13,000?
$500.
$500. Right, this
$13,500, the yearly fees of the son, which is taken care of by the father. It is stated that there is a property in the name of the son, from which he is deriving an amount of rupees 50,000 per month towards rent. The wife had filed the settlement deed in respect of the said property before this court, which shows that the said settlement deed is revocable, and during the lifetime of the father, he will be enjoying the property. He'll have control of the property, and he can develop the property as per his wish. Looking at all these aspects, no, full stop. Land counsel appearing for the response, our husband submits that wife is having the fixed deposits in the US. She was a US citizen. She was working in a bank. She has a capacity to work, but she is not working. And she had filed as many as, there are as many as 75 cases pending between the parties. In response to that, it is a case of the wife that whenever she gets an interim order against that, they prefer an appeal. And in fact, in this case also, they've gone before the Honorable Supreme Court, questioning an interim order that is passed by this court. It is submitted that right from the year 2011, this particular case, she's going around the courts fighting this litigation. And even till now, as per the order of the court, she is not able to enjoy the fruits of the same. Next paragraph. So this matter is posted for hearing at the request of the party in person. Looking at the perusal of the order, the documents that are marked before the court on behalf of both the parties, and particularly the submission of the land counsel for the petitioner that the court had come to such a conclusion and granted the maintenance more on assumptions and presumptions. This court is of the view that the basing on the material that's available on record, there cannot be that this court will not be able to pass a just and reasonable order. When her wife had filed 155 documents, husband simply comes with 7 exhibits, and looking at the lifestyle and the manner in which the husband is living, or the income tax returns and other aspects, when the court gives a finding, now it's a submission that it's on the assumptions and presumptions. Nobody has stopped the husband from placing all the facts which are necessary before the court. It is stated that they have placed the documents which are available with him. This court is not able to understand or appreciate the same. The documents which he feels or he feels are not the documents that have to be placed. Even as per the judgment of the Honorable Apex Court in Rajneesh versus Neha, these documents cannot be considered, or this cannot be said that these are all the requirement by the husband. These are all the documents that has to be filed by the husband as per the judgment of the Apex Court in Rajneesh versus Neha. In this case, the husband had, when the company has taken over by the Swiss company, and in that transaction, what is the amount the husband had, what is the transaction between the Swiss company and the petitioner? Petitioner is nowhere forthcoming. Only the petitioner is trying to say that he is getting a monthly income of 55,000, which is now reduced further, and for the full stop. Still, he is in a position to take care of the son, and also by settling a property in favor of the son, he submits before the court that 50,000 he is deriving rents from that property. Even a bare perusal of all this shows that the husband has not disclosed all the relevant aspects before the court to grant maintenance to the wife. It is immaterial to the court whether it is husband or the wife. What is material is the requirement when an application comes up before the court, whether the wife requires maintenance, and what is the financial capacity of the husband, and what would be the appropriate compensation to take care of the needs of the wife. To come to the conclusion, what is the amount? Both the parties have to be fair to the court, and they should come up with the documents and the real figures figures, and basing on that, the court would pass an order. Here is a case. As far as the wife is concerned, the husband says that she is having the properties. It's for him to show. But as far as the husband is concerned, on the facts that are already referred to in the preceding paragraphs, it appears that the husband has not come before the court with all the documents. In that view of the matter, this court is passing the following order. The husband shall file an affidavit before this court with regard to his assets, his immobile and mobile properties, and particularly about the husband and wife, both petitioner and respondent shall file immobile and mobile properties, and particularly the transaction with the Swiss company as it has happened subsequent to filing of this petition. That is, this petition is of the year 2011, and the transaction was in the year
2013 also.
2013, which is very much relevant for the purpose of deciding the case. So, point number 2. If any of the statements that are filed before this court on an affidavit are not true and correct facts, the court would be initiating appropriate proceedings against both the parties. When do you want?
Must be grant me about,
1 minute.
must be grant me about 2 weeks time, Lord.
This is matter after 2 weeks, give a date.
My
Not-
lordship, if
can I
an
make
order
one-
regarding maintenance, because they're paying only 12,000. It's
Now,
clearly showing that
please
they're not-
understand. No, there is no stay. This court has not extended the stay.
Agree, my lord.
You are not precluded from executing that. No, there cannot be any further order saying that you pay the money, because already there is an order in your favor. Either it is by the family court or by this court. It doesn't make any difference. For both the cases, you have to execute the order.
But an
But can I
interim
seek
order-
one indulgence, Lord? Lord, may say the observations made in this order, Lord, are only, Lord, shall not come in the way, Lord, at the time of final arguments. It's only prima
The
facie.
observations made by this court are only for the limited purpose of deciding this application, and it shall not come in the way of the parties. Yes.
Grateful.
A specific date may be given, my lordship.
Yes,
Need to come
they'll,
back from-
they'll tell you the date. Exactly after 2 weeks, give a date. Yes, next.
That is
30th.
Yes, next.
Can it be on 1st of July, Lord, instead? 1st of July instead of 30th of June. Great.
1st of July.
Please.
Yes. Next.
Much obliged, my lordship.
Cell number 16, Latif B.
Appearing for petitioner, my lordship. Like delay may be condoned, my lordship.
He has not served so far. How will they file counter objections to this? The petitioner shall serve a copy of the petition by today on the land council for the respondent. Lissus matter. Interim order is there.
No, my lordship.
Lissus matter. When? When do you want?
You get
On 20th. Yes, next
Number
17.
17,
appearing for petitioner, my lordship. Delay may be condoned, my lordship.
Why? Without notice to the other side, delay will be condoned. Notice to the respondents.
cell number 18, Geeta Devi.
There are two connected matters in this. I have filed
If
for
somebody is
vacating
making a
of-
representation in the morning for adjournment in another case, Geeta Devi's case,
Yes. That is in,
they sought for time in the morning.
yes, in serial number 32.
That is 32
The
matters.
respondent-
This is, this connected matters are serial number 18 itself.
Where is she? You have any urgency in this?
My lords, the urgency is there is 80,000 that was ordered by the Honorable Trial Court. I have challenged that, saying 80,000 is not sufficient because the husband earns about 42 lakhs and is not taking care of the kids nor the wife.
No representation. List
My
is
lords, this
matter
is
for
the
dismissal.
8th time that they've been seeking adjournment.
Dismissal. List is matter for dismissal day after tomorrow. No representation for the petition in WP number 18607 of 2023.
Cell number 19.
Hearing for the petition, it has to be heard finally. At the stage of the final hearing of final hearing, when he making a submission, the that stage this application came to be filed, suppressing the very judicial proceeding. I'm filing a memo of the judicial order.
What happened? What is this?
Again, it's
Stay was granted specifically for stated that as and when the daughters seek for the amount, it shall be the duty of the father, that is the petitioner, to pay. Now, till today, my lord, not even a single penny has been paid.
No, there's a false submission.
To pay the amount, educational expenses is being taken care of, but the day-to-day affairs, my lord, requires some amount. And
kindly peruse your lordship order, your lordship order dated 5/3/2024. Lordship order dated 5/3/2024.
5/3.
Before that, the first order 4/12/2023. This is the interim order. Later, your lordship passed the order.
Yes, 5/3 order.
Yes, ma'am. Before that, 4/12, that is first order.
First order is 4.
4/12/2023. The petitioner before this court calling in question.
1 minute.
Calling in question order dated 3/10/2020 passed in this criminal miscellaneum 403 of 2000 by the third additional pursuant so for which the petitioner is directed to pay the maintenance to wife and children. Learned counsel for the petitioner submits that petition is always taking care of the children and is ready to take care of the children for all time to come to for which it is submission that an order of maintenance
Yes,
will
I've
not
seen
be
that.
required.
I've seen that. Next.
Yes, ma'am. Your lordship order 5/3.
Yes.
That is complied. Your lordship last parameter, whether the wife is entitled of so and so, your lordship directed to us to them to pay 3 lakhs of the wife and also directed her to submit. Till this day, that order is not complied. And 2 lakh is in the fixed deposit.
Hence, the interim arrangement, the wife is then permitted to withdraw an amount of rupees 3 lakhs from the amount which is
Yes.
deposited before the court below, and the remaining amount of rupees 2 lakhs shall be kept in fixed deposit in the name of the children. The respondent wife shall file the statement of expenditure. But no, why are you relying on that order?
What has happened is, my lord, wife is not filing this application. My lord, the stay was granted
No,
as
no.
far as the wife is concerned.
No, please understand. After that order, this court has passed an order on 5/3/2024.
My lord, that was 5 lakhs, my lord, subject to the deposit of 5 lakhs. Vis-a-vis the wife, my lord, the stay was granted by.
My respectful submission, madam, instead of
Let him say. Yes.
4/12/2023, my lord, vis-a-vis the wife. The stay was granted, my lord, on the condition that 5 lakhs be deposited before this court. My lord, 5 lakh, my lord, was deposited. Then, my lord, an application was filed before my lord. In that, my lord, 3 lakhs wife was, my lord, permitted to withdraw. My lord, and was, my lord, asked to, my lord, file an affidavit regarding her expenditure. As far as the 2 lakhs is concerned, my lord, in the name of the children, fixed deposit was there to make. That has been done and completed.
You are appearing for whom?
I'm appearing for, my lord, the wife and the 2 daughters. Now, as for the 2 daughters are concerned, the specific undertaking that the father gave before this honorable court is, as and when I would seek amount.
Please
my lord,
understand.
without there being any-
You cannot read the 2 orders and understand something. Now an order is passed first, thereafter this order is passed.
This order
Do you
was-
say that like this order you have to read independently and take 3 lakh? And as for the first order, there was no such direction.
Please see the first order, my lord. There.
First order is no more now. After that, it's a continuation of that. Now, because that day court has not defined anything, then this court has permitted that 2 lakhs be kept in the fixed deposit, 3 lakhs to be withdrawn by the wife.
Now the undertaking given by this will take care of the children. That, my lord,
We will hear it finally.
yes, ma'am.
Let this matter is coming up for admission or in orders?
So already admitted, my lord, why your last is twice heard and
The I number 1 of 24. This court is not inclined to pass any orders, and the matter will be heard finally. List this matter for final hearing.
Well, the
Call for
interim
the
order has to
TCR.
be extended.
TCR is already there. Admit. Next.
Cell number 20.
It's already there.
It is here.
Petition is only on an interim maintenance. I'll be able to, my lord, proceed with the main case. And hence, TCR
Oh, this is a writ petition. Yes.
only on an interim maintenance.
But it is already there here.
But the reason is, my
Well,
lord,
let it send
Let
it back.
Let the
I
TCR,
can complete.
the
my-
registry is directed to send the TCR.
Interim order has to be extended. ma'am.
Interim
Much
order
of-
extended.
Cell number 20.
My lords, I appear for the petitioner in serial number 20. We wish to withdraw the matter, my
Sanjay
lords.
Sunny.
Yes, list this matter tomorrow.
Cell number 21.
21, my lords, I appear for the respondent wife, my lords.
For the petition.
I have moved an application for vacating stay on the ground that the conditional stay has not been complied with. The areas of.
We'll have it afternoon. Pass over.
Your Lordships, if I may make the submission, Your Lordships, we have
Tell
already
me,
spoken to the party. We have advised them to offer some.
No advice. Don't have to advise them. They should know. Well, if not, we'll vacate the matter.
Your
Vacate
Lordships may
tomorrow.
have it tomorrow. I'll file my objections. Your Lordship.
What objections?
To the vacating, it has been
I'm
served
not
only
going
to-
into the vacate stay application at all. There is a conditional order. Whether you are complied with or not is the only question.
I may be permitted to.
No further arguments. If the interim order is not complied with, I'll vacate it on that ground. Please find out, only you have to get instructions on that. And he's already saying that it is not complied with. Yes, next.
Cell number
22.
22.
Pass over this matter. 21 pass over.
21 pass over.
Yes,
22.
22.
Manjunath BR.
It will be passed over.
Pass over.
Cell number 23.
Yes, remaining matters in the afternoon.
My lord, serial number 24, my lord. I pray for a week's time, my lord. We'll file objections. The
Who has moved the memo?
The petitioners.
When they have moved the memo, how can you make a request for
My lord, I've
adjournment?
informed the petitioners, my lord. They have.
You have no objection? List this matter after 2 weeks, 24, at the request of non-counsel for the respondent. Week, my lord. 2 weeks.
Much obliged, my lord.
All the matters afternoon.
ಮಧ್ಯಾಹ್ನ ಸರ್ ಎಲ್ಲಾನು ಕರಿತೀವಿ.
ಇದಿಷ್ಟು ಡೇಟ್ ಅಪ್ಪ.
ಅಯ್ಯೋ ಎಸಿ ಆನ್ ಮಾಡ್ಕೊಂಡು
ನಾನು ಆಫ್ ಮಾಡಿದೆ, ಅವರು ಆಫ್ ಆಗಿದೆ ಅಂತ ಆನ್ ಮಾಡಿದ್ದಾರೆ.
ನಮ್ಮಲ್ಲಿ ಕೇಳ್ಬಿಟ್ಟು ಅವರೇ ಆಫ್ ಮಾಡಿಸ್ಬಿಟ್ರು, ಬಾಗಿಲು ತೆಗೀಸಿ.
ಡೇಟ್ಗೆ ಒಂದೆಲ್ಲ ಕಳಿಸ್ತೀನಿ.
ಇದು
ಇದಿಷ್ಟು ಬರ್ಬೇಕು ಮೇಡಮ್. ಇನ್ನು
ಡೇಟ್ ಇಲ್ಲ ಬರ್ಕೊಟ್ಬಿಟ್ಟು ಸೈನ್ ಟೈಪ್ ಮಾಡ್ಬೇಕಾ? ಹೌದಾ, ತುಂಬಾ ಇದೆಯಾ?
ಅದೇ ಇದ್ರದ್ದೊಂದು ಲೆಂತ್ ಈಗ ಇವ್ರದ್ದು ಡಿಆರ್ ರವಿಶಂಕರ್
ಆಯ್ತಾಯ್ತು. ಬೈ ಫೈಲ್ ಈಗ ಇದು ಕೊಟ್ಟೋಗ್ತೀನಲ್ಲ ಸದಾ ಫೈಲ್ ಕಳ್ಸಕ್ಕೆ.
ಎಲ್ಲಿಗೆ ಹೋದ್ರು?
ಫೈಲ್ ತಗೊಂಡು ಹೊಟ್ಟೋದ್ರು ಬ್ರಾಂಚ್ಗಳಿಗೆ. ಅಟ್ಲೀಸ್ಟ್ ಡೇಟ್ಗೆ ಒಂದು ಎತ್ಕೊಂಡು ಹೋಗಿ ಆಯ್ತಾ ಕಮಲ್ ಹಂಗನ್ನು ವೀಣಾ ಹಂಗನ್ನು ಅವರು ಇವಾಗ ಫೈಲ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ, ಇನ್ನೂ ಲೇಟ್ ಆಗುತ್ತೆ ಫೈಲ್ ಬರಕ್ಕೆ. ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರು
ಸರ್. ಲೋಕ ಅದಾಲತ್ ಯಾವಾಗಿನ ಅಂತ ಗೊತ್ತಿಲ್ಲ, ನೀವು ಅಲ್ಲಿ ವಿಚಾರಿಸ್ಬೇಕು. ಅದೇ ಪಾಠ ಲೋಕ ಅದಾಲತ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಒಂದ್ಸಲಿ ವಿಚಾರಿಸಿ.
ಕಮಲನ ಕಮಲ
ಹೌದು, ನಾಳೆಗೆ ತಾನೇ ಇರೋದು.
ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಈ ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಒಂದು ಕಳಿಸಿ. ನಿಮ್ ಫೈಲ್ ಇದೊಂದೇ ತಾನೇ ಬೇಕಾಗಿರೋದು. ನಿಮ್ಗೆ ಯಾವ್ದು ಒಂದ್ ಫೈಲ್ ಬೇಕೋ ಅದು ಆರ್ಡರ್ ಟೈಪ್ ಮಾಡಕ್ಕೆ ಅದೊಂದು ಎತ್ಕೊಂಡು ಹೋಗಿ. ಇನ್ನು ಉಳಿದಿದ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸ್ಬಿಡಿ, ಟೈಪ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು ಸೈನ್ ಮಾಡಿಸ್ಕೊಡ್ತಾರೆ. ಆರ್ಡರ್ ಶೀಟ್ ಒಂದು ಕಳಿಸಿ, ಸೈನ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಫೈಲ್ ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸಿದ್ರೆ ಸಾಕು.
ಇನ್ನೂ ಊರಿದೆ
ಫೈಲು ಫೋಟೋ ಎಲ್ಲ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಡಿ.